This week on C-SPAN's Afterwards podcast, author and University of Michigan law professor Leah Litman argues that the Supreme Court is no longer practicing law and that it displays a commitment to protecting a single minority. In her book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes, Leah Litman explains why she believes the Supreme Court isn't making rulings based on legal principles. Leah Litman is a former Supreme Court clerk, co-hosts the podcast Strict Scrutiny, and writes about the Supreme Court for many publications, including The Washington Post and The Atlantic. During this hour-long episode, she speaks with author and Nation magazine justice correspondent Elie Mystal.
Hi, and welcome to C-SPAN's Book Talk. I am thrilled to be joined by Professor Leah Litman, author of the new book Lawless, which, generally speaking, is about the Supreme Court and how we got here. Professor Litman, how are you?
I'm doing well, Ellie. I'm super excited to be here with you.
Well, thanks so much for doing this. Thanks so much for writing this book, and happy launch day. The book is available everywhere. They still allow liberal books to be sold.
I.e. not at the Supreme Court bookshop.
Certainly not. I want to start asking you about style before we get into substance. You are a constitutional law professor. You've written many law review articles. If people are interested, I still consider your law review, the Michigan Law Review article about disparate impact and disparate discrimination, to be one of the best explanations of that subject and where we currently stand. This book is not written like a normal constitutional law professor's book now, is it? Going through it, I feel like I did not see one reference to Leonard Hand or Oliver Wendell Holmes, but I saw quite a few references to Taylor Swift, and probably there were more that I missed as I am not fully read up on her entire body of work. So can you talk a little bit about like the stylistic choice in writing this book, and why you went about it in the way that you did?
Yes, absolutely. So when I started thinking about writing a book, I wanted to write a book that would be accessible to a general audience and that I would have fun writing and that I would hope people would have fun reading. Because the topic of the book, the story I tell about how the Supreme Court has basically been taken over by the rich and reactionary elements of society and the Republican Party, is not a happy one. And so I needed to find a way to make this story that is enraging and troubling also be empowering to people, so that they would read it and come away wanting to fight and feeling informed. And in my way of thinking, being irreverent and using gallows humor was partially the way to do that. I also think the Republican appointees are behaving in ridiculous ways. And so writing in this tone was a way of cutting them down to size and ridiculing the ridiculous.
I think that's right, and I think that's so important. I think that a lot of times in our society we treat the Supreme Court justices as gods, as our lay clergy, if you will, and we forget that they're humans with kind of normal human traits and foibles and emotions, and as you point out right in the introduction, real weird kinks with their flags and whatnot. And I think kind of explaining to people that these guys and women are human is really important. How did you decide kind of which human stories to pull out versus which legal ones to pull out?
Yeah, so the different chapters focus on different areas of law that, to my mind, reflect this idea of conservative grievance, this feeling among the Republican justices and the Republican Party that they are the victims whenever they are criticized or whenever a law doesn't go their way or when society doesn't share their views. So having picked the areas of law, I wanted to focus in all of the chapters on some of the real world implications and practical effects of the justices' decisions. Because one through line in the book is, in my view, one big problem, one way in which the Supreme Court has become so off is they have become very removed from the actual lives of people whose lives are affected by their decisions. So the first chapter, which is focused on reproductive freedom, begins with the story of Marin Michelle Hollis, one of the individuals, one of the women who was profiled by ProPublica in the aftermath of the court overruling Roe versus Wade. And all of the chapters have at least one story of at least one person who is affected by the court's decisions to cash this out as far as what the court is doing to the country and to society. So how I picked those stories, it was really a combination of different reasons. One is timing. I wanted to focus on Marin Hollis's story because she tried to get an abortion basically within weeks of the court overruling Roe versus Wade, and tried to get one basically the week before, or the week after rather, Tennessee's restrictive abortion ban went into effect. So her story, I think, illustrated the harshness and the absurdity of the court so dramatically refashioning the law in that one decision. So there were different factors that went into picking which stories went into the book, just depending on the chapter.
It makes sense to me. Let's get into the substance of the book and that first chapter on Roe v. Wade and the Dobbs decision. You call it the Kenification of the Supreme Court, and I think that reference is brilliant. When I was watching the Barbie movie as Ryan Gosling descended into darkness, I literally turned and said to my wife, like, "Oh, they're playing Ken like he's Brett Kavanaugh." So explain a little bit about what you mean by the Kenification of the Supreme Court and how that led to the loss of a constitutional right for the first time in American history.
Yeah, so I liken what the Supreme Court is doing to our Constitution, specifically in the area of reproductive freedom, to basically a Kensurrection. So in the Barbie movie, Ken goes to the real world, he gets a little taste of the patriarchy, he decides it slaps, and he comes back to Barbie Land, this feminist utopia, and tries to remake Barbie Land into a patriarchy. But to do that, he has to adopt a new constitution in the land of Barbie. So, what I think the Republican appointees on the Supreme Court are doing, they're taking our Constitution, which admittedly is highly imperfect, but in part because of the Reconstruction Amendments, 14th Amendment, as well as the 19th Amendment, which guaranteed women the right to vote, the Constitution does allow, women substantial rights and the ability to participate equally in civic society. So what the Republican appointees did is they are trying to transform our Constitution into a Constitution. How are they doing that? They're turning over the content of our Constitution to the bunch of white men, the Kens, who drafted and ratified the Constitution in the 1700s and 1800s through a jurisprudential method of originalism. The way it works is they ask, what rights do we have today? What can our government do? By asking the people who drafted and ratified the Constitution in the 1700s and 1800s. So by outsourcing all of the questions to a group that's more sympathetic to their project of turning the country back into a patriarchy, they too are engaged in a Kensurrection.
Do you think they come by their originalism honestly, or do you think that it's always been nothing more than a means to an end, right? If you want to unpack, take away a constitutional right, if you want to send women literally back to the dark ages, you can you can't say that that's what you're trying to do outright, right? So you have to come up with a theory that justifies your approach. Do you think that's how it started, or do you think they kind of honestly believe in this and that leads them to throwing women back into the dark ages? Like, it's probably a little, six of one, half dozen of the other. But how do you kind of weigh it up? What's the ratio, do you think?
Yeah, so I think when originalism kind of took off in the 1980s, they picked up this theory that, of course, had originally been used to challenge Brown versus Board of Education, the decision to, desegregate public schools. So as a methodology, it was already clear that originalism was going to turn back the civil rights of groups that haven't always been allowed to participate equally in American society. And I think different people glommed on to originalism for different reasons. And I think the same is probably true for the Republican appointees on the Supreme Court. Take the author of Dobbs, the decision overruling Roe, Samuel Alito. He's not an originalist. He just used something approximating originalism to overrule Roe because that's what he wanted to do. He is much mocked originalism in other cases, accusing originalism of asking questions such as what would James Madison think about video games? So he doesn't actually believe that originalism is an interpretive methodology that we should use to interpret the Constitution. It just so happened to be convenient in that case. I think some of the other appointees probably think differently. I think Justice Barrett has really convinced herself that originalism, other methodologies like textualism, are the one true principled method. Now, I think she is getting a harsh awakening as she works alongside her Republican colleagues. So I think the answer is probably different reasons for different people, just as it was when originalism kind of took off.
Why do you think so many women accept the training, accept the okadoke of originalism? One of the things that always I think shocks non-lawyers is when you go to a Federal Society conference, you go to one of their cabals, and you'll see quite a few women in those conferences, in positions of power. You'll see a lot of minorities, not so much with black folks, but you'll see a lot of other people of color buying into the training. How do you think that? What's the sell? What's the allure of originalism that seems to capture so many folks?
Patriarchy is a hell of a drug. So I'm going to answer specifically with respect to white women, who I take more than a few pokes and digs at in the first chapter. As I note, when the Republican Party started leaning into this movement where they wanted to restore traditional family values and restore the traditional differences between men and women, they started to lose support among women, but not all women, like not Amy, Justice Barrett. But I do think when I say patriarchy is a hell of a drug, what I mean is, we still have grown up in a society where most of the most powerful individuals are men. And so advancing yourself, right, often means getting the approval of men. And I think being an originalist and trumpeting originalism is one way of doing that because a lot of the most prominent originalists are white men. And so if you are socialized into a practice where you think you need the approval of men and you need to prove yourself to men, trumpeting originalism and being okay with the patriarchy is going to be one way of doing that. I also think for white women, of course, they view this in sort of a lens of race and sex. And for many white women, they probably think that their whiteness will insulate them from some of the worst consequences of reverting to a system, without civil rights for women, without reproductive freedom protections for women. So I think the answer, again, varies person by person. This is one of those questions where I wish I had, I'm not sure actually, I don't know if I wish I had a complete window into the psyche of all of the women who are cool with originalism and patriarchy, but it would be helpful to know what's going on there.
Yeah, like with the truth serum, what's the real story behind the mask? Um, why do you think so few Democrats, so few liberals um understood what the threat was? Like I've been listening to you on Strict Scrutiny for a long time, long before Dobbs, and you were sounding the alarm, screaming about how this was coming. I've been screaming about how this was
Mhm.
coming pretty much for my entire career, and yet so many people seem to think that it was never going to happen. So many people thought that abortion rights were ironclad, despite all evidence to the contrary, despite all of the efforts Republicans had made over the decades to take away this right. Why do you think so many liberals and Democrats were caught flat-footed?
One of the more remarkable memories that I have is even after the Supreme Court heard oral argument in the Dobbs case, when you
Yes.
had Justice Barrett floating the idea that we no longer needed the constitutional protections for abortion because people could simply drop their babies off at a drop box. And Justice Kavanaugh proudly rattled off all of the cases the Supreme Court had overruled before. Even then, people were still saying and convinced they weren't actually going to overrule Roe. Now, I think the reason why people deluded themselves into thinking this are multifold. One is, they had been lulled into a false sense of comfort by previous Republican appointees like Justice Sandra Day O'Connor, Justice David Souter, Justice Anthony Kennedy, who were appointed by presidents who had promised to overrule Roe, but they didn't end up doing so. Now, of course, that overlooked how the Republican Party had galvanized against those justices and refined its brutally effective screening mechanism to select people who would overrule Roe, but that's part of what gave people a false sense of comfort. I also think people on the left, Democrats and progressives, love to rush to the defense of institutions and defend institutions even when those institutions are decaying and crumbled. And so they looked at the Supreme Court kind of in the abstract and associated the court more with, again, the court that didn't overrule Roe versus Wade in Planned Parenthood versus Casey, or a court that had even protected the civil rights, equal rights of women, and just assumed, well, that is the nature of that institution, and therefore I will protect it. So I think, again, several different reasons, but those two definitely come to mind.
How do we fix this? Do we need an equal rights amendment? Do we need simply to get better justices on the court? Do we need the congressional legislation, the Restoring Roe congressional legislation, in some kind of fantastical future where Democrats are allowed to hold power again? How do we recover what was lost?
Yeah, so I think it is a problem in need of several solutions. One is I do think we need to change the composition of the Supreme Court. I think all of the great solutions that you named, like passing a federal statute that would protect abortion rights, are vulnerable to getting chewed up and spit out by the Roberts Court. There is absolutely no guarantee that five Republican appointees wouldn't hold unconstitutional a federal law trying to secure abortion rights or a federal law trying to protect voting rights. So, to my mind, that is and has to be one component of any Supreme Court reform, but I don't think it should be the only one. I think term limits are a very sensible solution that would regularize the process of Supreme Court appointments and also serve as a necessary reminder to people that when they go to vote for president and senators, they are voting for people who are going to select and confirm a Supreme Court justice. I am also personally in favor of various reforms that are aimed at reducing the power of the Supreme Court. So, if and when Congress hopefully passes a federal law protecting abortion rights or a federal law protecting voting rights, I think Congress should limit the authority of the Supreme Court to decline to enforce those federal laws, to say that they are unconstitutional. Now, of course, Congress could, in the event, as you say, Democrats are allowed to hold power again, enact that law without changing the personnel on the Supreme Court. But there, I think it's extremely likely, again, that the Republican appointees would strike down that federal law. So that's why I think changing the personnel and composition of the Supreme Court has to be part of any package of Supreme Court reforms that are designed to make the institution more reflective of the country we live in.
All right, so I was going to close with reducing the power of the Supreme Court, but since you brought it up, let's
Let's
embrace
do
the
it.
moment, Professor. Right now, right, people are concerned about people like us who have for a long time said that the Supreme Court needs to have less power than it does in our
Mhm.
democratic system. People are concerned about pushing those arguments just at the moment when the Supreme Court seems like the only institution, the only people in government that can do anything to stop the power of the, frankly, democratically elected President Donald Trump and his democratically elected Republican junta in Congress. So, how do you square the circle of kind of needing the Supreme Court to be less powerful as an overall democracy point, and yet also needing the Supreme Court to be particularly powerful potentially when we are living under this kind of direct threat to democracy?
Absolutely. If I could say a few things, one is it's definitely an interesting time to be writing and releasing a book about how the Supreme Court is bad, in part for the reasons you give. Part of what I hope the book does is it provides a necessary corrective to people's inclination to snap back to a world where they view the Supreme Court as good and as our savior. I expect the Supreme Court will occasionally rule against the Trump administration, but I don't think that means 3 years from now, 4 years from now, we should all be celebrating celebrating the great heroics of the Republican appointees on the Supreme Court. I think people need a longer term picture and a longer term assessment of the Supreme Court in order to really make decisions about what they want the role of that institution to be. The second is, I don't think we can overlook the ways in which this court and Republican controlled courts have laid the groundwork for Donald Trump. So, in many respects, they own everything that the president and Congress are doing right now, even if they occasionally rule against them and tinker at the margins. This court, after all, didn't allow states to disqualify Donald Trump from the ballot because of his role in January 6th and the Stop the Steal movement. They effectively said a portion of the 14th Amendment just couldn't be enforced against the president. They also cleared the way for his candidacy by slow walking the appeal in his immunity claims, ensuring he wouldn't face a trial on the election interference charges before the presidential election, and then granting him absolute immunity, or at least presumptive immunity, for anything he did as president. They also interfered with Joe Biden's ability to govern. They blew up one of his most significant policy achievements, the plan to cancel student debt. And if you look at some of the interviews with voters in the last election, many of them faulted Joe Biden and the Democrats for not doing student debt relief. But it was the Republican Supreme Court that effectively, again, impeded Democrats' ability to govern and deliver on the promises that they had made. So I don't think we can overlook the ways in which the court laid the groundwork for Trump and Trumpism in many different respects. And those are just a few examples. Third and finally, I would say, I don't think we should just shut down the Supreme Court entirely. I think any reforms about the Supreme Court have to be sensitive to the situation we are in, and I think they should be targeted. That's why I don't think we should have laws that say the Supreme Court can't strike down any federal law. I would want more targeted reforms that say, as to this Voting Rights Act or as to this Restore Roe Act, we are going to limit the Supreme Court's authority to strike them down. But I don't think we should have a system where, the Supreme Court cannot be assessing administrative regulations or other matters.
C-SPAN's Afterwards podcast continues in a moment. Now back to C-SPAN's Afterwards podcast.
Yeah, you can't see me, but I am nodding vigorously with everything you're saying. I think that one of
Music to my heart.
I think one of the truly disturbing things that I've heard from Democratic leadership in this moment, Chuck Schumer, saying that, well, when Trump defies the Supreme Court orders, then Democrats will fight with everything they have. And what you're waiting for? If you've got more fight in you, why aren't you unloading the ballast right now? But B, why are you giving 6 Republican judges the ability to tell you what's legal and not legal? Like, why do you think that they are the ones who know more than anybody else? And so that, I'll phrase that in the form of a question. Why do you think so many people believe that the Supreme Court, regardless of its partisan makeup, is the kind of final say, end all be all of what is legal, what should be legal, what should be allowable in this country, when we have branches that we elect to do that work for us?
I think the answer probably varies depending on who we're talking about. As for Democratic officials, I think many of our geriatric political officials grew up and were socialized during the era of the Warren Court, where they went to law school and learned the Supreme Court is great and heroic. And so that's the institution that they imagine when they are asked questions or thinking about what should we do about the Supreme Court. And they've just never updated that since. I also think it partially reflects a failure of our public school systems. I teach constitutional law to first-year law students, and every year I ask them, how many of you have heard about Reconstruction? How many of you have heard about Brown versus Board of Education? They all raise their hands. And then I ask, how many of you have heard about redemption or the Lost Cause movement? Or how many of you have heard about the Supreme Court's decision in the civil rights cases, invalidating the first federal Civil Rights Act? No one. And so I worry that we are sending people out into the world to vote as citizens without a fully realized picture of the Supreme Court. And part of what I hope to do in the book is to socialize people in a very different picture of the court.
Excellent, excellent. Well, so we've done in the middle what I was going to do at the end, so I'll come up with a different ending. But I want to get back to the book, and I want to jump ahead. You talk about voting rights as well, and that story is very similar to the abortion rights story. So I kind of wanted to jump ahead to money, and I don't want to give the whole book away. People should buy it and read it. But I kind of want to jump ahead to money in politics and the Supreme Court's leading role in corrupting the American political process through the kind of unfettered use of money in our politics. Can you talk a little bit about that chapter and about your thoughts there?
Yes, absolutely. So this chapter goes back to the Supreme Court's role in the Lochner era and its role in exacerbating economic inequality, in the lead up to and in the aftermath of the Great Depression. And it argues that basically at the time, the Supreme Court forced the government to blind itself to the realities of economic inequality and actually insisted that laws that were designed to address economic inequality, laws that tried to level the playing field between the haves and the have-nots, did not fully or sufficiently take into account the interests of the rich. That is, they framed the problem as these laws actually discriminate against the rich. Fast forward to Citizens United versus Federal Election Commission, when the court invalidated, the first piece of campaign finance regulation that kind of launched their full-out assault on campaign finance regulation. There, the justices insisted that the mere fact that people spend oodles and oodles of money in politics does not lead to corruption, is not corruption, does not even create the appearance of corruption. It was instead the constitutional right and an entitlement of people with that kind of money to spend. As the court steadily cannibalized more and more of campaign finance regulation, knocking down not just the restrictions on corporations' ability to spend unlimited amounts of money, but also the ability of individuals to contribute unlimited amounts of money to corporate PACs or political action committees, and the ability of individuals to contribute unlimited amounts to candidates and political action committees combined, that created this system where the mega rich can spend an unlimited amount of money and just overwhelm our system of political spending compared to anyone else. And one of the more ridiculous aspects of these decisions is here too, the court insists that any other system would just be unfair to the mega rich. So when the court struck down these aggregate limits on campaign contributions or aggregate limits on contributions, things that tried to limit, the total amount that an individual could contribute to all political action committees or all campaigns, the court said those laws interfered with the right of people to choose who will govern them. Well, whose rights are interfered with when the government caps the total amount of money that can be spent? It's the super rich. And apparently, they are entitled to choose who to govern us. And so part of what I want to do in the chapter is expose the extent to which the court is fawning over the interests of the mega rich and treating them as an aggrieved class that needs the protection of the federal courts. And in the process, reshaping American democracy. When they say oodles amounts of money, all of this money and all of these gifts don't create appearance of corruption or corruption. What they're doing is they're legalizing influence and access schemes where the mega rich can spend all of this money and in exchange get influence and access to political officials. If you look back at the 2024 election, you had the richest man in the world pour in several hundred millions of dollars to basically buy himself a position as shadow president or vice president. If you look at the news, Donald Trump purportedly accepting this luxury jet from the Qatar government. You see people saying, well, that's not corruption because it's not an explicit quid pro quo agreement where Qatar provided the plane in exchange for a particular favor. That is the definition of corruption that the Republican appointees on the Supreme Court have adopted, that clears the way, again, for the mega rich to just shower political officials, including Supreme Court justices, with a ton of money and a ton of gifts and buy themselves an audience.
I know you wrote this chapter before the rise of Elon Musk as our shadow president, but this chapter is basically how Elon Musk won, how the
Yes.
Supreme Court um, uh, uh, created the conditions under which Elon Musk could win. Can you talk a little bit about how the court's decisions in Citizens United and the unfettered access of money in political campaigns also has led to, and you mentioned this a little bit in your answer before, the corruption of the Supreme Court itself? I'm thinking not just of Clarence Thomas and his RVs and his wines and his free vacations. I'm also thinking of Brett Kavanaugh and
Yeah.
his opinion, decision, ruling, self-serving, self-dealing, that bribery is okay, apparently, if you're just bribing the judge for a job well done. Can you talk about how this led not just the corruption of our politics and our elected
Yeah.
branches, but also the corruption of the lay clergy, the Supreme Court itself.
Yeah, so just going back to this idea that the Republican justices are so convinced that money in exchange for influence and access isn't corruption. Based on that idea, they have refashioned the law of political corruption in the United States and also created a system that allows the mega rich to get influence and access to the justices themselves. So I just want to give one example of the law of political corruption before I tie this to the justices. So
Mhm.
there was a case last term where the court asked, is it bribery? Is it a violation of federal law for people to provide tips or gratuities to state and local officials? Even or to provide tips or gratuities to state and local officials if they didn't have a particular agreement that said, I'm giving you this tip or gratuity in exchange for you doing me this favor. And in an opinion by Brett Kavanaugh, the Supreme Court's Republican appointees said, yeah, that's not bribery. That's not corruption. That's just kind of how government works. And they are so obsessed with this idea that, of course, the mega rich are entitled to spend their money to get influence and access to political officials. And of course, political officials are entitled to hear from their constituents by being showered with this gifts and largesse that they have applied this rule to themselves. So it's not just Justice Thomas, as you note. Justice Samuel Alito was exposed by ProPublica for taking a private jet trip for this luxury Alaskan fishing vacation by Peter Singer, a billionaire who had a ton of business, who had at least a case before the Supreme Court, that Justice Alito participated in. And Brett Kavanaugh and Neil Gorsuch have been sent off to these delightful summer trips in Europe by George Mason University, their school of law, which has received a ton of money from the conservative legal movement, the Koch brothers, that was arranged in part by Leonard Leo. And so you have this system where the conservative legal movement is funneling a ton of money to socialize the Republican appointees and what it now means to be a conservative and what the Republican Party wants now. And that system, if you just observe it from the outside, it's gross. I mean, again, you have Justice Thomas, reportedly, according to ProPublica, telling Republican congressmen that if you don't raise the salaries for Supreme Court justices, you're going to get some retirements. And the Republican congressman basically responds, you're right, we need the proper incentives. And so what happens? You have all of these billionaire benefactors step up and provide the justices with the lifestyle that they apparently feel entitled to in order to give them pats on the back for reaching these decisions that allow the rich and reactionary, to control our political system.
Can you go a little bit deeper on, you just said it so well, go a little bit deeper on socialize them to be Republicans, because I do not believe, and I don't think you believe, that what's happening here is a straight up cash for votes, right? Clarence Thomas is crazy enough on his own. He's going to vote the way he's going to vote on his own. He doesn't need money to do that. He has his own, he needs his wife to do that, right? But that's not what we're talking about. We're not talking about here's some money in an envelope and then you're going to vote my way on, Dobbs or whatever. But we're talking about keeping them in an environment where they are, as you put it, socialized in a certain way to believe certain things, to believe that a world that doesn't exist actually exists all around him. I always think about Roberts allegedly being shocked, according to him, that his decision to grant Trump king-like powers was so controversial. I'm like, what rock have you been living under where you could possibly be shocked by that? And that rock is, of course, all of the money of Republican donors around him. So go a little bit deeper on the socialization point that you made.
Yeah, absolutely. So as you say, this is not a quid pro quo system, the kind of bribery that the Republican justices, thinks is actually problematic. All of these appointees, they grew up conservative, they grew up Republican, they have conservative and Republican views. But what I think this money is doing is a few things. One is it is providing them with needed validation and affirmation. So we all know Brett Kavanaugh desperately wants to be well liked and popular. And
Oh,
so,
desperately. Like
right,
it's
very
he smells the desperation on him.
Yes, yes. And so part of what the conservative legal movement, tried to do is counter what they thought was, they described as the greenhouse effect. When you put Republican appointees on the Supreme Court, they would drift left because they would read negative media coverage about how their revanchist decisions weren't great for the country. And because they wanted people to like them, they would move left or to the center. And so what the conservative legal movement did in part is it created this well-funded ecosystem that would give the justices applause and affirmation for reaching the results that the Republican Party and the conservative legal movement wanted them to reach. And so that isolates them and again cocoons them, in this constant stream of applause and adoration, if they do the things that the Federalist Society, conservative legal movement, and Republican Party want them to do. But another thing that I think is at work here is it allows the conservative legal movement and Republican Party to signal shifts in their position. So, one of the chapters in the book talks about the Republican justices' reversal on the Chevron doctrine. The
Mhm.
Chevron doctrine was this idea that, well, when courts are interpreting statutes that are unclear and that administrative expert agencies implement, courts should defer to those agencies' reasonable interpretations of the statutes. That used to be a Republican favored doctrine. Justice Scalia was a huge champion of it. Then all of a sudden, you had the Republican appointees reverse course and overrule it last term. So, how does that happen? Well, the conservative legal movement puts on all of these panels, public education, amicus briefs, retreats. Academics are writing law review articles. And so the justices receive all this information because they are part of that network. And again, that signals to them, this is what my party, this is what my people believe now. And so, of course, that is then going to seem to them more reasonable. Again, they're not accepting the benefits in exchange for voting to overrule Chevron. They are just being immersed in this world where they now see all of the things that Republicans and the conservative legal movement now believe. And so, again, in this highly polarized universe that is a well funded ecosystem that is spending a ton of money to get the justices, all of this messaging and all of this campaign, that is going to influence them.
And you can see them trying to take away those applause from Amy Coney Barrett. Every time Amy Coney Barrett sides with the other women on the court, and we have seen a couple, not enough, but a couple of 5-4 decision men, boys versus girls on the court. Every time she does that, they come at her neck. The right wing comes for her in the press, in the media. Josh Blackman, with really harsh and unkind statements about one of their own
Yeah.
every time she fails to toe the line in a way they don't for Brett Kavanaugh when he does the same thing. There are some 5-4 boys versus girls opinions. There are many more 6-3 Roberts, Barrett, and Kavanaugh all join the liberals for a decision. There are more of those. And when those happen, they still come for Barrett, not Kavanaugh. They've always come for Roberts. They never have liked him very much. So you can see them trying to take away that cocoon from Barrett. I imagine to keep her in line. Is that what you're seeing too?
Yes, that's also very much what I perceive is happening here, as to the fact that this movement and this group, attacks her more than her male colleagues. Again, I would just say the patriarchy is never going to accept you, girl. This is part of why women shouldn't be down with the patriarchy. But part of what is so fascinating to me watching this play out is I agree with you. They go after her. It is very ugly. They call her a DEI hire. They say we can never appoint women to the Supreme Court. They just can't be trusted. But there is then this public facing debate that plays out where while some people within the conservative legal movement and Republican Party are going at her so hard, you have other people within the movement suggesting, look, let's criticize her, but don't be that mean to her because we don't actually want to push her into the arms of the left or the centrist. So she starts seeking affirmation or validation there. And that, to my mind, is just a pretty explicit, apparent recognition of the disciplining function of the conservative legal movement and their public-facing commentary, they are very self-consciously and intentionally trying to work the refs and influence them by signaling, here's what we want you to do. We will, again, clap for you and be very happy with you if you do those things. And we will be out of our minds if you don't.
But it's
And they are trying, sorry, go ahead.
it's also just so like infantilizing to me, right? Because the idea that well, if we're too mean to her, she'll cry in the bathroom and go with those leftists. So we have to like come on, like there is no, and I argue about this with people on the left. There is no version of events where Amy Coney Barrett becomes your friend. I don't
Yes.
care how mean they are to her on the right. She's not going to change her mind on abortion. She's not going to change her mind on civil rights just because people were mean to her, any more than you would expect Brett Kavanaugh or Sam Alito to change their mind on those issues just because you're mean to them. So there's also like this infantilization that happens with Barrett that really, I mean, I hate, I trust me, you know, I'm not trying to defend the woman, but like it really pisses me off.
Yes. Yeah. So if I could just say two things about that. One is I completely agree with you. Amy Barrett is not the left's friend. She has very clear, very apparent, very strong conservative beliefs. She is with the Republican appointees, completely lockstep to the right of some of her Republican colleagues, on some issues. The fact that she is peeled off in, a number of cases that I can count on one or two hands, just is not an indication that she is going to be your savior. But, as to this is infantilizing, I agree. On the other hand, maybe it's worth remembering that these are also people who are used to, in part, dealing with Brett Kavanaugh. And so they might just be assuming that everyone craves the same kind of like validation or affirmation that he does. And, it's also true, though, that this is not going to move the justices. I mean, the Chief Justice, who has been persona non grata in the conservative legal movement ever since he voted to uphold in part the Affordable Care Act in 2012, I mean, he's still reaching very Republican decisions. He struck down Voting Rights Act. He's dismantled campaign finance. He has voted with the Republican appointees on all of the cases expanding the rights to discriminate against LGBTQ individuals. He has voted with them in the Trump cases, the immunity decision and whatnot. So the fact that he isn't welcome at the FedSoc gala does not change the fact that he is a Republican.
C-SPAN's Afterwards podcast continues in a moment. Now back to C-SPAN's Afterwards podcast.
Exactly. I don't want to leave money and politics without talking about your recent Nation article. I have to promote that, contractually obligated to promote that, about money and speech. People will argue that money is speech, and you make the argument in the Nation this morning that Republican justices have a very free speech for me, not for thee approach to money and politics, especially when it comes to unions. So can you kind of take people through that argument a little bit?
Yeah, absolutely. So to the Republican appointees, the First Amendment seems to give you the right to say things they like, to say Republican things, but not so much anything else. So, famously, Citizens United versus Federal Election Commission invalidated this federal law restricting corporations' ability to spend money to promote and advocate for candidates. And it did so notwithstanding the fact that corporations obviously are funded and represent, shareholders or employees, not all of whom might agree with the positions that corporations take. So that didn't seem to bother the Republican justices there. And yet, when it comes to unions, the court invalidated public sector unions' ability to require what are called fair share fees from union and non-union members, basically fees that are collected in order to pay for the lobbying that unions do on behalf of all employees. And the court invalidated that measure in part because they said, well, look, not all individuals are going to agree with every position that a union takes. So, of course, we have to protect their First Amendment rights. and not allow unions to take, these positions based on contributions that aren't going to represent the views of absolutely everyone, who might contribute to the union. Elsewhere, Justice Alito has ranted and raved about how, some individuals chose not to spend money in states, chose to boycott states with certain laws that, targeted the transgender community or the LGBT community. And the idea that it's a problem how people choose to spend their money, is of course completely antithetical, to this idea behind all of their campaign finance decisions, which says, the super rich are entitled to spend their money however they would like and to overwhelm the political spending of everyone else. So yes, they are very selective in their attention to First Amendment principles. In some cases, they protect the rights of conservative individuals to donate anonymously to conservative organizations. So they are protecting, you know, money as speech. And they do so in part because, as Justice Thomas, expressed concern about during the oral argument, well, look, some people aren't going to like the fact that they're going to be accused of being racist or homophobic if they donate to those organizations. So they are protecting the right of these conservative donors, these conservative organizations to spend their money, to be free of criticism while spending their money, thereby restricting, or affecting the First Amendment rights of others while protecting the First Amendment rights of conservatives. There's so many examples of this. It just drives me insane, for a group of individuals who has been screaming about being free speech warriors and warning about the dangers of cancel culture. These are the same individuals who are now part of an administration that is trying to deport, a graduate student for writing an op-ed. These are the same individuals who say you can't have, LGBTQ inclusive reading material in schools because that's just so offensive to me. So they are extremely selective in their commitment to the First Amendment, be it speech, be it money, be it you name it.
How do we again, how do we stop this? Like, how do we break their control over the courts, given that the Democratic Party seems to be so still in the woods about the Supreme Court? You talked earlier about how, part of the problem with Democratic leadership is when they went to law school and their
Yeah.
reverence for the Warren Court and all of that. And I totally agree with that in terms of a leadership perspective.
Yeah.
But there's also, I want to kind of access your experience as a law professor. The when you're on campus, and I think a lot of people who've never been to law school don't kind of know this, the Fellow Society is all around you, right? With the best food, right? With the best
Yes.
kind of
Although I did
events.
get E. coli at a Federal Society event when I was in law school, so note of
Oh, did
caution.
you?
I
That's
did.
amazing. I got lobster rolls, right? Now you gotta I got really good, the real good clam chowder when I went to FedSoc events, which is why I went to FedSoc events. As a poor law
Yeah,
student, free food,
free
you're
food.
gonna go. I don't think that people who haven't been on campus understand just the financial imbalance
Yeah,
between the Fellow Society on campus and all the other groups, and that is in an environment where liberals outnumber conservatives in law school
yeah,
2 to 1, 3 to 1,
yeah.
depending on the law school. It's not, law schools are not a conservative environment, and yet the conservatives are so omnipresent in law schools. Like, how do we break that, the pipeline problem that liberals face when it comes to creating our own justices and judges?
Yeah, so I think it is going to require a lot of time and a lot of investment. So I'll just rattle off, a few ideas. One is I do think part of the solution is public education. For anyone who has not read Jane Mayer's book, Dark Money, read it. It will radicalize you into how these organizations actually function and make you see, exactly how pernicious some of the influence of all of this dark money and these organizations and their influence over education has been and continues to be. So one step is just informing people, about how these organizations are funded, how they operate, asking people to read more about the Supreme Court. I don't think it's an accident that Donald Trump's approval ratings have plummeted in part on immigration at the same time that the news and commentary has been quite focused On the treatment of the men in the terrorism confinement center, the case of Kilmar Abrego Garcia, who was wrongfully sent there, the case of other individuals who were wrongfully sent there. So the more people know, the more equipped they are going to be to have informed opinions that are capable of influencing public debate and the positions that political officials might take. Second is, I think, organizations on the left, donors on the left, have to be willing to invest in the courts. Right now, you have a lot of big donors on the right willing to pour in obscene amounts of money to support, conservative ideas on campus, or to support individuals who want to focus on taking over the courts. Leonard Leo has acquired vast, vast, vast amounts of money that have allowed him to develop this pipeline of future Republican appointees to cultivate conservative talent and to get those ideas out on campus and elsewhere. And I think Democratic donors have to be similarly willing to support those causes as well. The other thing I would say is start building those networks on the state and local level, because those are going to be, the future judges and the future political leaders, at some point down the road. I think, again, the Republican Party and conservatives knew this. They were trying to stock state courts, state legislatures, with people who they, believe to be entirely aligned with their movement. I think people on the left and progressives need to be thinking about, okay, like, let's just not use judicial appointments as a way of rewarding people who have supported the party, but instead let's view them as a mechanism to advance our progressive ideas and to build a progressive vision of the law and of the country. So I think it is adopting a different vision for how judicial appointments work, adopting a different vision for the kind of individuals to promote in politics and who should be political leaders. It's partly a public information campaign that is designed not just to talk to the Democratic base about the courts, but also Democratic donors and Democratic political officials as well.
Yeah, I mean, look, I always say you can go to your least common denominator MAGA voter, and you cannot convince me that the least common denominator MAGA voter is any more civically educated than
Yeah.
the least common denominator liberal voter. But the least common denominator MAGA voter understands that they have to control the courts.
Yeah.
They understand it in a very kind of visceral, kind of, salt of the earth way,
Yeah.
but they get that if they want to keep their guns, they need the Supreme Court. Like that is a thing that they will tell you. If you go to a liberal and you're like, how are we going to address climate change? How are we going to address the issues that matter to you? Supreme Court is not going to be on their list. It's not even going, much less at the top of their list. It's not even going to be on their list. And I think that goes a little bit to what you've been talking about in terms of public education. But I think it goes a lot to the leadership of the party. We haven't told our people that the Supreme Court is important as it is, and that the entire federal judiciary is as important as it is. So let me get you out of here on this. Who's next? Who are you? I mean, you close and again, I'm not going to give it away, but you close the book with a examination of the American psychos on the Supreme Court. Who's the next American psycho that we can expect? That you are afraid of? We'll get an appointment. Should Samuel Alito retire or Clarence Thomas retire, or the random wheel of death happen tragically to somebody?
This is a very bleak question to end on. So I am going to give it a bleak answer and list four names. One, Eileen Cannon, the judge in Florida that single-handedly ended the most open and shut case against Donald Trump involving obstruction of justice and wrongful retention of classified documents. Second, Jim Ho, who has been auditioning so hard for this seat. He has written that the word diversity itself might be evidence of illegal discrimination. He has, taken opportunities to gesture toward fetal personhood, the idea that fetuses are people entitled to constitutional rights, such that the Constitution requires abortion to be illegal everywhere. Another potential candidate, Andy Oldham. He was a judge, one of the judges on the panel that would have restricted medication abortion nationwide. He has also written opinions that have taken completely gratuitous shots at Joe Biden and suggested, he was not with it at the end of his presidency and didn't know what he was signing. So he too is really gunning for that seat. Fourth candidate, dark horse. I don't think he's going to get it, but got to name him anyway. Matthew Kacsmaryk, the judge who
Oh
initially
God.
ordered the nationwide ban on medication abortion, who dressed his children up in T-shirts that said, "I survived Roe versus Wade."
Oh God. I wouldn't have put a Matty K on my list of horrible. He's so far away. He can't get that job. I'm most afraid of Jim Ho. You didn't
Okay.
mention his how he analogized women to pregnant women to beasts in the wild. Like they're zoo animals who need to be protected so people can look at them and their pregnant bellies. Uh,
Well,
um,
so that was one of the opinions that I said was suggesting gestured toward fetal personhood. This is the case where he suggested anti-abortion doctors had standing to challenge the availability of medication abortion because they experience an aesthetic injury when babies aren't born. So therefore, in order to be happy, they can commandeer women's uteruses.
And then, so yeah, so that's the list of horribles. Who are the list? Who's on your list of heroes? Who are the potential liberal judges? Again, should liberals ever be allowed to have power again in this country?
Oh
Um, um,
man.
who are the ones who are out there fighting the good fight, and should get more shine for their work?
Many options. I mean, one thing Joe Biden did very well is nominate a bunch of really wonderful people to the lower courts. So
Look,
I,
I've said repeatedly that Joe Biden made the best set of judicial nominations in American history,
yep.
bar none, and I am including Barack Obama in
Oh
my
yeah,
definition of American history. His slate of judges were diverse, not just racially and ethnically,
yep,
but gender-wise and
yep,
experientially, a true
yes,
diversity of experiences on the court. And I feel like if anybody let him down, it was more the Democrats in the Senate who
yep.
didn't confirm all of his nominees when they had the opportunity.
Yep, completely agree. So just a few names. Judge Amir Ali on the District Court for District of Columbia. He's the judge that invalidated the attempted shutdown of the United States Agency for International Development. Judge Dale Ho on the Southern District of New York, a very successful, famous voting rights litigator, civil rights litigator before he joined the federal bench. Judge Julie Rickleman, she is on the U.S. Court of Appeals to the First Circuit. She was the person who argued Dobbs on behalf of the abortion clinics. Rachel Bloomkatz, a lawyer who has represented consumers. She was appointed to the Sixth Circuit. So those are four names, but again, there are many, many terrific options.
Professor Lippman, thank you so much for this book. Thank you so much for your work. Thank you so much for humanizing the law for people who don't have the stamina to go through every single Supreme Court opinion. Is there anything else that you want to highlight about your work that I wasn't able to ask you about?
I would just say, the book is intended to be, a fun, lighthearted read about a very troubling, disturbing story. It is designed to empower people and to invigorate you, and I intended it to be for a general audience. I grew up hanging out at libraries and independent bookstores. I love books. I loved writing this, and I hope people enjoy reading it.
Well, I certainly did. Thank you so much again for your work. Thank you all for tuning in. Again, the book is called Lawless, and it's available everywhere today. Professor Leah Litman, thank you so much for your time.
Thank you.
Thanks for listening to this week's Afterwards podcast. If you are interested in podcasts about nonfiction books, listen to C-SPAN's Book Notes Plus podcast for interviews with authors and historians hosted by Brian Lamb.